Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before I get started, I have to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association says I've got to say this, so now I've said it. Nothing will ever prevent me from giving you an easy-to-understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. UNUM, much like many disability carriers, has a history of arbitrarily denying disability claims. In fact, they do it so frequently that today's episode is just our second iteration on the topic. Do you have a policy through UNUM? If so, listening to today's episode will give you insight into UNUM's handling of various types of claims. And even if you don't have a UNUM policy, you're going to get valuable insight about how disability carriers play the disability denial or termination game. So I'm going to talk about four things today. One, UNUM's termination of a long-term disability claim paid for 12 years on the basis that chronic migraine policyholder was at maximum medical improvement. Two, UNUM is told to pay $20,000 per month in long-term disability benefits to a disabled merger and acquisition attorney. Three, UNUM is called out by the court for using a nurse consultant rather than a qualified healthcare professional in a claim denial. And policyholder triumphs in MS-related cognitive impairment disability claim against UNUM. It's going to be a information-packed full podcast, but before we get started, let's take a quick break. Welcome back to Winning Isn't Easy. UNUM's termination of a long-term disability claim paid for 12 years on the basis that the chronic migraine suffering policyholder was at maximum medical improvement. Now, just because a disability carrier approves and pays for a disability insurance claim for years doesn't mean that they're going to continue to do that until the end of the policy period. UNUM is no exception. In fact, it's one of the primary offenders when it comes to creating reasons to terminate benefits. So let me tell you the story of Ms. Iravani, who was a cosmetic beauty specialist for Saks Fifth Avenue. She became disabled because of chronic migraine headaches and degenerative disc disease. She was paid benefits from 2010 until her benefits were terminated in 2021. That's, practically over 10 years. So what happened was that she was 61 at the time they terminated her benefits, and they justified this claim termination on the basis of the following: that there was convincing evidence of improvement in her medical records. Two, that her doctors were all in agreement she was at maximum medical improvement. And three, notwithstanding her pain, she was miraculously no longer disabled. Now, these reasons were created by a UNUM liar for hire peer review doctors who ignored, cherry-picked, and otherwise obfuscated crucial parts of her treating physician's records and opinions. In fact, UNUM's doctors never spoke with any of her 7 treating physicians. So what did the court do? For her benefit, she had the de novo standard of review, which is the best standard of review that you can have. And so the court was not bound by the arbitrary and capricious standard of review and limited in the way it could analyze the evidence. So using the de novo standard of review, the court disagreed with UNUM's conclusion that there was sufficient evidence of improvement. In part, they were taking the position because she was not taking narcotic medication. Now, just because you're not taking narcotic medication doesn't mean you've improved. And the judge did note that while her doctors agreed she was as good as she's going to get, in other words, at maximum medical improvement, they were still all the opinion that she was disabled because of the permanent restrictions on her ability to sit, stand, and walk. So what happened, of course, was that UNUM and UNUM's doctor cherry-picked the records to get the result that they wanted. And in fact, they used 2 of their favorite doctors. There's Dr. Stuart Russell and Dr. James Lewis. I see them all of the time in UNUM denial cases and denial cases with other carriers. In fact, what I would suggest you do is use Google Scholar and put their names in and see the number of reported cases involving these two doctors. Using these two doctors' opinion, UNUM justified the termination of benefits. But in fact, a close review of the medical records documented that she complained of consistent to moderate severe pain, describing her pain at a level of 7 at its best, 10 at its worst, on a scale of 1 to 10. And as you read the medical records, the complaints were consistently documented in her medical records. In other words, there was this longitudinal history that was consistent and observed and recorded by more than one doctor. The court found that this was credible. In fact, the judge openly chastised UNUM for its failure to explain how her chronic headaches and degenerative condition would improve over time, when in fact there had been no improvement. And in fact, in view of her age, the degenerative changes would expected to get worse, not better. Thankfully, the court overturned UNUM's wrongful denial of benefits. And you can see that this is going to be consistent with UNUM's approach to disability claims, using liar-for-hire peer-reviewed doctors to back into reasons to justify a claim denial or a claim termination. Got it? Let's take a quick break.
Been robbed of your peace of mind by your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claims process. Request your free copy of the book at caveylaw.com today.